A full Supreme Court bench comprising 5 judges on Friday heard arguments in a case brought by independent presidential candidate Dr. Panduleni Itula and others seeking to nullify the outcome of the 2019 presidential elections. Administrative law lecturer at UNAM John Nakuta and the director of Citizens for Accountable and Transparent Society, Carola Engelbrett, both made their analysis during the live broadcast of the court hearing.
The ECN thinks that political parties are their main stakeholders, while I have been saying the electorate is, because it's for us.
Yeah.
It's our people that we want to. So I think then this court case also highlights the importance of the electorate to feel at ease with the EVMs. They must feel okay that they can see the button I pressed is for the person or the party that I wanted to elect.
And
on his part, Nakuta says the court argument took a rather surprising turn as the applicant decided to take a different premises of the argument as opposed to what was anticipated, that they might attack the purported irregularities at the polling stations.
with that, they are not saying that there were no irregularities. However, they are addressing the issue of principle. Because basically what they are saying in terms of the act, in terms of Namibian law that is, elections can be set aside based on two things. One, if there were material irregularities, as we've mentioned in the beginning, but also if there were non-compliance with the principles as enshrined in Chapter 5 of the Electoral Act. And they are basing their challenge on the principle. On the principle act. Very, very interesting.
The applicants rather decided to base their case on the alleged unconstitutional conduct of the minister in omitting subsections 97 of the Electoral Act, which provides for the concurrent use of EVMs with a verifiable paper trail.
The ECN is saying that we did not, we complied with that notion of the right to vote. We've got systems in place that protect the integrity of the vote, the issue of transparencies. We've got other things. And so the judges are basically saying, but you did not, and of course the applicant is saying that, yes, that is administrative compliance, but you did not comply with the statutory protection which the court, which Parliament actually intended for it to happen.
In a telephonic interview, constitutional law expert Professor Nico Horn said the court challenge saw among the most well-formulated in Namibia history and may give a bench a hard time in coming to their conclusion.
There is a chance that the court will eventually decide in favor of the applicants. And before the case today, there were very few legal practitioners and legal experts who wanted to believe that the applicants had any chance. And I think a lot of people will feel a little bit differently today. And I'm not saying that it will necessarily go in their favor, but I think that it was not an empty, hollow application that they brought. There is definitely a strong possibility that the court may decide in their favor.
Now, in terms of the law, we are required to render judgment 14 days after the conclusion of the hearing of the application.
Chief Justice Peter Shivute reserved judgment to not later than 6 February in a case many describe as a watershed court challenge. I'm Daniel Nadunya, NBC News, Windhoek.